Office of Mpp Jagmeet Singh.
Could I speak to Nader, please?
Hi, speaking.
Yeah, I'm reading the transcripts. It says, do you have a police report? I said, I don't. I said, do you? She says, yes, but I can't take it from there. So what's in the police report doesn't matter.
No, that's not true.
It says it right there.
No, hold on.
Do you have a police report there? I do, but I can't take it from there. Says you don't have a police report there.
No, she's saying that she can't take, because you asked her, because she asked you, I believe it was February 19th. I'm not sure on that date, but I think it was that day. She's like, you will have to confirm that day for me. You have to know who you are charging when the event occurs.
Yes.
She's like, you don't have a police report there? She's like, I do, but I can't take it from there. She's saying she has to take that information from you personally.
Yes, but you keep saying she's going by the police report.
No, that's part of her overall ruling, is what she has in front of her.
But she says I can't take it from there.
No, because right here she's taking down information.
Yeah, but you keep bringing up the police report, saying she's basing it on that.
No, when you meet with the justice of the peace, you have to provide information about what you're.
Yeah, and you're saying my word is not enough. Like my word, you're saying that's not enough. Just me saying what happened. And you have no other evidence.
No, not especially not when you're the one who started the fight.
But the criminal code doesn't say you can hit somebody just because they hit you.
But that's not how the judge interpreted it.
But the judge is not reasonable in her interpretation. I give her the facts.
That's your opinion of what happened. That's your opinion of the judge's ruling. But the judge's job is to interpret the criminal code and apply it to specific cases. In this case, she's applying it to your case.
Yes, but she's not reasonable.
When she applies the criminal code to your case, she's saying no. There's not grounds for a criminal charge. That's it. That's all it is. There's not a cover-up. There's no conspiracy theory here. She's saying there's no criminal case. There's no case to be made.
Yeah, but she says what he did is an assault because I assaulted him first. But the criminal code says you have to have a reasonable belief that your force is going to be used.
She believes there was.
Based on what? There's not my evidence.
In front of her.
Not my evidence. There's no evidence of that. In my testimony.
You disagree with her. She thinks there is.
Based on what, though? That determines the reasonableness of it. What's her thing based on? Not my evidence. And that's all she's going by.
No, that's not all she's going by.
She says I can't take it from the police report.
You can't take the answers as to who you're charging.
No.
Yes, look, it says right here.
No. She's talking about the whole thing. She doesn't say.
She's asking you questions about what happened, and you're providing answers. And then you're like, well, don't you have it in the criminal? Don't you have it in the police report? Don't you have a police report in front of you? Like, why are you asking me all these questions? Do you have it in the police report? And she says, yeah, I do, but I can't take those answers from you.
Why would she not be able to take my address from the police report? Come on.
Because she has to make this report.
So if she can't take my address from the police report, surely she can't take evidence from it either.
She has to confirm the basis of the case from you.
Yeah, and I don't give her any evidence that he had a reasonable belief that force was going to be used.
She believes that, based off of what you told her, she thinks her interpretation is that it was a fight, and that's it.
But that's not what I told her. I told her we walked away from each other, and then he walked over to me and assaulted me. What's me on top of that?
You don't have any evidence that you have no witnesses. She even mentions that. She asked if there's any witnesses.
Where does the law say that one person can't testify by themselves? Where does the law say that? Well, where does the law say you can't have a he said, she said case?
No, you can, but the judge can determine whether or not it goes to court.
Yeah, but what she bases you don't know what she's basing it on.
No. Imagine if every he said, she said case went to court.
No, you base it on, if she wants to talk to him, she can go to talk to him after she's done with me. But she says that she doesn't believe it was an assault. Like,
you can't lay, but it's very difficult.
But you don't know. So what was she basing her decision on then?
The judge has a judge's interpretation. You don't have to agree with the judge's interpretation for it to be a lie. Just because you disagree with what she...
But it's not even close. The criminal code says you have to have a reasonable belief that the force is going to be used.
I'm going to repeat one more time. She interprets it as he did.
Based on what? I didn't give her any evidence.
Based off of her interpretation that it was just a fight and that there was no witnesses to corroborate your...
What's a witness got to do with anything? Now, see, now you're back to saying it's a he said, she said thing.
Of course it is.
But the people go thrown in jail based on what one person says all the time. The law doesn't say you can't file charges against somebody because it's a he said, she said case.
That's even worse. She's not going to charge someone just because you came in and said he did this.
Sure she is. They do it all the time. That's why the police said, here, go declare information in front of the justice of the peace.
No, she even says, I can't put this before the courts because of that.
Because she says I assaulted him first.
Yes, because that's how she interprets it.
But it's not reasonable, her interpretation of it. She's interpreting Section 34 to mean that you can hit somebody after they walked away from you.
But
it doesn't.
She doesn't think that that's how it happened.
She didn't say that.
She's clearly saying, I understand what you're saying, but in the end it clearly was what we would call, in our common sense, call a fight. And
she's lying. It wasn't a fight. Well, look at the evidence. Look at what I said to her. I said we walked away from each other.
Saying, look at the evidence. You mean look at what I told her?
Yes, that's evidence.
And the fact that there's no other evidence to support that.
What's that got to do with anything?
Because that's what the judge determined whether something should go to court.
But I just said to you, people get thrown in jail based on what one person says all the time.
No, they don't. They have to. There's a lot of investigations that go into those. Investigations go on all the time.
So you say there's no ever a case where it's he said, she said, like a rape case.
Rape cases are very different, extremely different.
How are they different?
Because that's dealing with the immediate safety of the public. If there's a rapist out there.
Where does the law say it's different because of that? I mean, if someone assaulted me, that's the safety of the public.
Sir, you're the one making the claims. You have to provide the evidence. You only provided your own testimony. You have no witness testimony. You have no physical evidence.
But she has no evidence to contradict it, though.
And you tell this judge, she doesn't have to provide evidence to the contrary. You do. You're the one making the claim. The onus is on.
I don't have to provide evidence of the contrary. She has to. If she doesn't believe me, she's obligated to explain why she doesn't believe me.
She does. She says that she believes it was a fight. She believes that she believes that it was a fight, and that you assaulted the person first, and then it was a fight. That's it.
But the criminal code doesn't say.
The criminal code, I understand, doesn't say that, but she doesn't think that that's how it happened.
She doesn't say that.
Yes, she does.
No, she doesn't. She said it was a fight.
Yes. So
right.
She doesn't think that what happened was she doesn't think that the way you described it is how it happened. Otherwise, she wouldn't call it a fight. She would have agreed with you. She doesn't agree.
But she has no evidence in front of her to contradict what I say.
She doesn't have to provide evidence.
You just said she doesn't believe what I say.
You have to. You're the one who has to provide evidence that a crime occurred.
Yes, and my word is in some cases is enough.
In some cases it is. In some cases it isn't. In this case, the judge interpreted it and said, no, it's not enough to lay a charge of assault. That's it.
Based on what?
What do you mean based on what?
On what evidence? What contrary? What?
She interpreted your evidence as it being a fight. She heard your evidence and she said, sorry, it's a fight. It's not an assault charge. Move on.
But the criminal code says it is an assault charge.
No, she interpreted it.
How can she interpret that? How can she interpret from what I said that he had a reasonable belief that force was being used on?
Because you assaulted him first.
No. Talking about when he assaulted me. At that point in time, he had to have a reasonable belief that he was.
She could easily then interpret it as, well, she doesn't have to believe what you say if she thinks that that the fact that you assaulted him first could have played a role in that fight happening.
But the criminal code doesn't say that.
You assaulted him first, that it escalated into a fight. That's it.
Yeah, he assaulted me after.
That this judge is trying to lie to get you out. Like, why would this judge lie to you?
Because the courts are swamped and JPs are under pressure not to answer that, just like the police do. My landlord stole stuff out of my room. I called the police. They said it's not a police matter. Oh, someone stealing something is not a police matter? There's an example of police covering something up.
The judge simply interpreted what your evidence. You presented your evidence, which was just your account of what happened, and the judge said, no, sorry, from my perspective, from my interpretation of what happened, it was a fight. That's it.
And is that reasonable?
I think it's 100% reasonable.
Based on what? Well, what? Based on what? You believe she was reasonable. Based on what evidence do you believe that?
Because if someone assaults somebody first, it's completely reasonable to say that person reacts.
But they can't react 30 seconds later, or the criminal code.
Later,
the criminal code.
If someone assaults you 30 seconds later, you hit that person back. That's a fight.
No, it's not. The criminal code says.
In the judge's interpretation, it was.
No, your interpretation of it was. You just said you thought her judgment was reasonable. The criminal code says you have to have a reasonable belief that you're.
And the judge believes that in your.
You just said you believe that too. So tell me what your belief is. What evidence you have of that?
I don't have to have evidence. You're the one.
You just said you believed the justice of the peace was reasonable.
Yes, in interpreting what you said as being a fight.
Based on what? Well, what are you basing on?
Your own testimony.
But the criminal code says you have to have a reasonable belief that you're about to be assaulted in order to use force.
And the judge believes that that was a fight. And
you believe the judge is reasonable on that. What's your?
I think it's a reasonable conclusion to come to, that if someone assaults somebody and that person hits that person back, it's not assault, it was a fight.
But that's not what the criminal code says. The criminal code says you have to have a reasonable belief that you're being assaulted.
Right, and it's very reasonable to assume that if someone gets hit, that they have a reasonable belief that they were going to get assaulted. And that's clearly what the judge interpreted.
Then it's reasonable for me to believe that he's about to assault me when I hit him.
Yes, and that's why it was a fight.
No, the criminal code says you have to have a reasonable belief that you're about to be assaulted.
The judge believes that in your case that was present.
Where? Where's the evidence of that?
They don't have to present evidence. You're the one making the
claim. You just said the justice of the peace believes that. Where was that based on?
Because the judge says that it was a fight.
Yeah, based on what?
Based on your own testimony and the fact that you hit him first.
Yes, and then we walked away from each other, and the criminal code says you have to have a reasonable belief that you're about to be assaulted.
The judge still interprets that it was a fight. Done.
Based on what, though?
Based on the fact of your own testimony and that you hit him first.
But the criminal code doesn't say that, though. It doesn't say because someone hit you first, you get to hit them back. It says you have to be defending yourself.
Right.
And there's no evidence of me attacking him.
No, you seem to understand. You and the judge have a different interpretation of what happened.
Right, and you say that the judge's interpretation is reasonable. It's not reasonable at all. Even the police say it's not right. The police say the justice of the peace is right because the assault charge would be hard to prove. They admit the judge.
And why would the assault charge be hard to prove?
I didn't say the assault charge would not be hard to prove.
No, but why would the police say that?
I don't know why the police would say that.
Because the evidence isn't there. That's how if something's hard to prove, it means there's not enough evidence to prove it.
Yeah.
That's why it's hard to prove. That's why the police never say that the judge was wrong.
Yes, they did. They said the justice of the peace was right because the assault charge was hard to prove. They didn't say the justice of the peace was right because that's a reasonable interpretation of the law.
So where does the police say that the judge was wrong?
They said the justice of the peace was right because the assault charge would be hard to prove.
Again, one more time. So where does the police say that the judge was wrong?
Because they said she was right because the assault charge would be hard to prove. They did not say she was reasonable in her interpretation.
So, hold on. So where did they say the judge was wrong?
I didn't say they specifically said she was wrong. You're so screwing me around, man. And this is going on my website, man. All this conversation.
I'm trying to understand why. I'm trying to understand how we can help you. Because in this case...
But you're just screwing me around. You're clearly screwing me around.
No, I'm trying to understand what the case is that you're trying to make and how we can actually help forward your case. Because I've told you before that I don't think we can. Our office it's beyond the purview of our office, and that as much as I wish we could help you, I have a very hard time understanding much of your case. And so I think that your best bet is to pursue your case.
It says on the transcripts, and there were lots of witnesses to this. His knuckles bleeding.
Which one?
The assault charge.
But you say that there's no witnesses.
No, I didn't say that.
You say there's no witnesses to the actual fight.
The actual fight, but there was witnesses to his knuckles bleeding.
Right. So there's no witnesses to the actual fight.
Well, how did his knuckles again start bleeding then? They need to investigate that.
But they clearly say that you say it yourself. There's no witnesses, and you even refer to it as a fight. That doesn't really help your case too much.
But I'm not the one making the decision. Just because we got into a fight, like you can't get into a fight with somebody and hit them later. You can't do that. The criminal code says that, and there's no evidence that he was believed that he was about to be assaulted.
No, I completely understand that you're frustrated, and I'm not going to disagree with you that the OIPRD is not a perfect organization. I think that there's a lot of problems with how they operate, and our MPP, the guy I work for, he's been very strong on trying to strengthen accountability for the OIPRD. Yeah,
but they're accountable to the Attorney General's office.
I really understand your frustration, but even I know we're having a heated exchange, but I'm really trying to work out what your claim is, and then trying to vet it with the evidence that you provided me.
But
I'm trying to do that, but I'm not. I wish I was.
Oh no, you're clearly screwing me. Anybody listening to this phone conversation would know that you're screwing me around, because you say that just so the police only gets my address from the thing. That's not what she says at all.
No, I'm not. So then, in that case, I will say I don't know exactly. But the thing is, neither of us do, right? Like, we don't know what the judge actually had access to when they were making this decision.
Well, she needs to be investigated then by the police to see if she had what evidence she had, right? Because it doesn't make sense what she's saying according to the criminal code.
Like, I understand why you would want it to be investigated. I just find it hard. I think it'll be a hard case to make, and clearly you've had a very hard time trying to make that case. And
yeah, because the police are covering things up. That's why.
Right.
Right. And NPPs won't do anything about it.
I understand what you're frustrated about, and I wish I could be of more assistance. Like I said earlier, though, if you can, one of the ways that we could definitely help you is if you were somehow able to get these claims verified by some sort of legal.
But lawyers, I've done legal work myself. I sued the RCMP twice myself. I know the law. I know how to interpret laws.
Right, and I wish I was.
A lawyer's just going to say the same thing I'm saying.
You think a lawyer would corroborate your story?
Yes, if it's an honest lawyer. But lawyers, like I said, they're scared of hard work, and they won't take on cases. Like if you tell them you don't want to sue, they might help you. If you make it explicit that you don't want to go forward with a lawsuit.
Right, I don't know. I can't say. I can't say one way or another. I'm not sure, to be honest. I'll take your word for it. But if you can, because we just need more.
So if I come up with a statement from a lawyer saying the same thing as I'm saying, are you going to believe it then?
I think it will definitely add credibility to your case. Yes, and it'll allow me to sort of have more of an understanding of what exactly we can do to help you, because I would have no problem furthering your case if I believe that there's something we can actually do. But based off of what I've seen, it's very difficult to say that there is. That's the only problem. And I'm not doubting what you're saying or saying you're lying. I just think that the facts need to be hashed out a bit more in order for us to be able to move forward with it. Because we're just an MPP's office. There's not much we can really do in terms of fleshing out the details of a legal.
No, but you can. The OIPRD director is accountable to the Attorney General's office, but they refuse to hold him accountable. And you can, your MPP guy can bring that up in the legislature.
Right, but I can't even necessarily hash out the exact allegations that you're making. Like I need, if you could make it very clear to me what it is that you would want us to bring to the attention of the OIPRD, then that's something that I can do.
Say that again?
If you could potentially put together, like in a very clear, simple way,
I've just done that, and you just twist my words around.
If you haven't, it has not been very clear. I apologize to say, but it's very hard for me to understand. And I need, if you maybe send me an email even, and just kind of very clearly lay out what the exact allegations are that you would want the OIPRD to be investigated.
Well, the one with my landlord stealing stuff out of my room. I filed a complaint with the OIPID, and they said that some section of the Police Services Act says that if the complaint can be better dealt with under another act, it has to be. So they said you should go deal with the police complaint under the Landlord-Tenant Act. The Landlord-Tenant Act doesn't deal with police complaints.
Right. I can't say one way or another. I don't want to say, and then I'm not too sure, to be honest. I'd take your word for it, but I'd have to look into it more myself.
I will email you the complaint.
So, if that's something that you can do, if you want to, because right now you've sent me a ton of attachments. And
but the lawyer's just going to say the same thing I'm saying. Because, I know how to interpret laws. The criminal code is written in English.
If a lawyer actually looks into your case and provides some sort of a documentation that can verify the claims you're saying.
Well, verify what claim?
Sorry?
Verify what claim?
But that's my very point. I'm not even sure which point it is, what claim it is that you would want to...
I'm saying that justice of the peace covered up the assault charge by lying.
On this one, honestly, on this last case, I don't think there's much our office would do in that case. Based off of my own interpretation of it, it seems very cut and dry that there wasn't grounds for... It just seems very straightforward that the judge...
So what about the threatening charge?
The judge said that she can't rule on that she has nothing to say on that.
No, I asked her, is that threatening? She says, I can't say. Why doesn't she just go look it up in the criminal code book?
Again, I can't say one way or another, but that's not grounds for... Again, I don't want to say one way or another, but I just don't think those are grounds for the police to then investigate the justice of the peace.
Yeah, but there's nothing... Like, she's not tied to the chair. There's nothing stopping her from getting the criminal code book out and looking it up. So clearly she's covering that up.
Maybe her issue was that even if she was to say... Like, she can't verify that claim was even made, though, besides your own testimony, right?
Yeah, but that's not what she's asking for, though. She's not saying, prove to me that happened.
From the judge's perspective, it'd be irresponsible for her to say, yes, that is a threat, when she can't even verify... She can't verify that threat actually was made. I'm just playing devil's advocate here, but maybe that's something that would seem very reasonable for a judge to do.
But that's why you go to a justice of the peace, to lay in information to see if there's enough evidence. Like, people get convicted and thrown in jail based on what one person says all the time.
Not convicted.
Yeah, lots of people have been convicted.
Not very often.
Look at the sexual harassment complaint that was filed against me, just based on what she said.
But that was just a workplace complaint.
Yeah.
That wasn't a criminal charge.
No.
A criminal charge carries much more weight on the person making the claim, because you're dealing with criminal charges. That's far different than a workplace complaint.
So you're saying no one's ever been convicted based on what?
No, I'm not saying that at all. I wouldn't know the history books, but I do know that in order for a criminal charge to be laid, there has to be a substantial amount of evidence before that charge can actually be laid, or else that would be...
No, there don't have to. You just got to prove it beyond a reasonable doubt. And if the jury believes me and not him, then he's convicted.
No, but we're looking at two different things. You're talking about conviction.
That's a higher proof than charging. Charging is a less burden of proof.
Right. The charge, in order for there to be an indictment, there has to be just at least my understanding. Again, I'm not a lawyer, but there should be proof that a crime was committed. Now, your proof would be that threat was issued, was stated by the suspect, but I guess the judge in that case felt that, for her to lay charges based purely on you making that claim, that's a very low bar for criminal charges to be laid, right? So
and you just said people get convicted and thrown in jail based on what one person says.
I never said that.
I said, so then that never happens. And you said, I'm not saying it never happens.
Again, I wouldn't know. I don't want to say one way or another. It'd be irresponsible for me to say that, because I don't know.
So if I find a case law where there's one witness testifying against somebody, then you say, okay, then it happens.
Well, because everything is case by case, right? Like if someone says, I saw that person.
Yes. Right.
Sorry?
Yeah, I agree. Everything's case by case.
Right. So even if there is an example, which I'm sure there is, of one person's written testimony resulting in someone being criminally charged, I'm sure there's a case out there like that. But I'm dealing with, in your case specifically, we would have to look at the details of your individual case.
Yeah, but there's enough evidence there for the police to investigate the justice of the peace. See why her decision was.
That's a very troubling direction to go in, though, if police start...
Well, how else do I do it? There's nowhere else you can investigate the justice of the peace.
No, you definitely have the right to request an investigation, but in this case, the police said, no, we're not going to investigate that based off of your charge that she lied.
Yeah, because the cops bring it up. I've asked them. They said your interpretation of the law and these circumstances is flawed. I asked them, how is my interpretation flawed? Well, we don't give out legal advice. Police explain themselves all the time.
They don't have to.
I'm not saying they have to, but they do. And if they got nothing to hide, why are they hiding things?
They chose not to.
Well, no, they can't choose not to. There's rules that say they have to be transparent. It's like the OIPRD has to be transparent, but they're not being transparent.
Right. Again, because we can go on all day. Like I think you've made your point very clear to me, and I completely understand your frustration. But in order for us to really help you in one way or another,
can I speak to Jagmeet Singh?
You'd want to speak to Mpp Singh?
Yeah.
Yeah, I can definitely schedule a phone call with you.
Sure.
Okay. Let me see. Wednesday?
No, can't do it Wednesday afternoon.
Can you do Wednesday? Okay. What about Friday?
Okay, Friday. What time?
Let's say 2 o'clock.
Okay. So I'll call you guys.
I can have him give you a call.
Okay.
Do you have a number?
289.
Yep.
768.
768.
4276.
4276. Okay, yeah, I can give you a call. No problem.
Okay, all right. Thanks.
Oh, okay.
Bye.
Thanks, sir. Okay, bye.